About our amendments and other basic protections that are provided for us through our Constitution. Again, and I should have just, I'm going to keep this like this, and sorry, but it's going to allow me to bounce back and forth a little bit here, which I kind of want to do. So amendments and basic protections are not absolute, right? So we don't say that, you can absolutely say anything and everything you want, although we support it fairly widely. But the example, I think famously Thurgood Marshall might have said, is that it doesn't allow you to yell fire in a crowded theater, right, when in fact there is no fire. Because the result may create a stampede then that would cause harm, injury, those types of things. And certainly then there would be some type of action that would be required against the perpetrator in that case. So they're not absolute in that sense, but we do hold them near and dear, right? So they're balanced, obviously then with public policy. But we've upheld some pretty, dastardly, free speech things. One of the worst in recent memory for me is the Westboro Baptist Church that has protested at service people's funerals, and their protest is based on the fact that they think that the reason we have service people dying is that we have decided to allow gay marriage in the United States, and so therefore they're protesting these funerals. Went all the way to Supreme Court though, and Supreme Court upheld their right to do that. And said no matter how distasteful, it's not inciting violence, it's not causing physical harm and those types of things, and so it's sometimes it's difficult to swallow, our First Amendment. We've got issues going on right now with the NFL and of course Trump bashing him and those types of things. So yeah, First Amendment's maybe getting tested again here. So okay. So the amendments remove issues from the political process, meaning that they're no longer legislated. I mean, these are rights, and keep in mind that the Bill of Rights, those first 10 amendments or the Constitution would not have been approved had those not been included. Those were demanded by some of the states and said, we're not going to approve the Constitution unless those basic rights are included. It can vary during emergencies, and perhaps the example of that, the worst example maybe of that, is the internment of Japanese Americans in World War II, folks that were probably loyal to the U.S. and yet they were interred simply because of their heritage. Okay, and so there's been other examples too where we've varied constitutional rights based on emergencies. So the First Amendment, and here's one of those things, man, let's go. Did you realize, I was looking at this, that this survey was done by the Annenberg Public Policy Center, 1,000 adults. So 48% of those surveyed were able to identify freedom of speech as being a right enshrined by the First Amendment, although far fewer could identify some of the others. So, governments make no law abridging the rights to freedom of speech. Freedom of religion is within the First Amendment, freedom of press, the right of peaceful assembly, and the right to petition the government, or the right to redress, and basically means the right to sue the government. Okay, would be maybe a shorthand version of that. So there's the right, all the things, the right to petition for redress we have down there at the bottom. They're within the First Amendment. Again, we oftentimes think it's only freedom of speech, but it's far broader than that. So keep that in mind. Might be on the test. So, breaking some of those down, again, a little bit more of the First Amendment. And the freedom of religion is, governments make no law establishing a religion nor prohibiting the free exercise thereof. And that can be held in employment discrimination. In fact, this was I was thinking of posting this, but I'll bring it up since it's right here. A waitress fired over religious objection to pants, and she sued Okay, but or the equal opportunity EEOC, and we'll talk about that when we get later chapters. But it looks like a sued on behalf, right? Lawsuit filed Monday says the Mississippi-based company failed to reasonably accommodate the religious beliefs of Katoya Watkins, who told a Georgia Blue manager that her religion prohibits her from wearing pants. Okay, and apparently they want them to wear blue jeans. Most of us would love to wear blue jeans. And she wanted to wear a denim skirt instead of the blue jeans. So I was going to wear denim, but wear a skirt rather than the blue jeans. And she was fired. So the EEOC in that case has taken her case. Okay? Obviously thinking that that's a case where at least a reasonable accommodation has to be made in regards to religion there. It's freedom of speech, right? There are speech that is unprotected. Okay, fighting words inciting violence. Again, the yelling fire in a crowded theater. You know, and it doesn't necessarily incite violence, but it incites harm or creates harm. Okay, defamation. Okay, defamation. And defamation, there's no prior restraint, really. In other words, we can go ahead and defame people, but we're going to be subject to possibly lawsuits in a case like that. And to a certain extent, obscenities. You know, we have placed limits on our TVs, for example, and whatnot. And one of the famous examples maybe goes back to the wardrobe malfunction of Janet Jackson at the Super Bowl years ago, and they put in some, subsequently they put in some rules. The FCC did, FCC did in regards to TV stations and showing things that might normally be considered obscene. And there's actually lots of rules that limit what can be said at TV during certain times to protect children, et cetera, et cetera. So, some public policy considerations there that definitely limit. When we go back to saying that our rights aren't absolute, and that's why we do say that there are some limits. So, Justice Potter Stewart, 1964. Can't really define obscenity, but know it when he sees it. So freedom of speech, symbolic speech also applies to that. So, kneeling for the national anthem, since that's in the big news right now, right? That's a symbol. It's not that they're saying anything or what have you, right? But that's considered symbolic. Okay. The overbreath doctrine says that there's right to challenge laws, though not directly affected by the law. And in some cases, this is given, like especially the press, the right to challenge or sue, even though the press isn't directly affected by the particular law or the restriction. Okay, and it's not just the press, but the press has, I think, typically been an organization or one of the organizations that would pursue these types of things. Normally, you have to have standing, right? Okay, but if somebody was their right to free speech was limited, maybe through the newspaper, though they wouldn't have a standing necessarily, they might be able to sue, okay, based on this overbreath doctrine. So, again, something that the courts are going to have to determine on a case-by-case basis. Commercial speech. So, again, is commercial speech protected? And the courts, and all the way up to the Supreme Court, have said, yeah, just like personal speech is protected. And like I've said earlier, the Citizens United case is fairly recent. Last 6 or 8 years, it went to the Supreme Court. The Supreme Court affirmed a corporation's rights to participate. In that case, it was right to participate in the election process by buying basically ads that they might want to push for their own candidates. So, okay, so it protects listener and speaker in commercial, and also freedom of information. And the huge recent court ruling was the Citizens United decision. So freedom of the press. Again, it's not absolute. So there can be some prior restraints on obscenity and defamation to a degree. Okay. But the press was designed to be, this is what it's saying, organized scrutiny of government. Or I shouldn't say the press was designed to be, but that's one of the functions of the press, was to be another rail of government outside of government to keep the government itself in check. Okay? And for the most part, they have the ability to do that. We get a little irpy sometimes when the government steps in and says they want to put some kinds of restrictions on the press, and now that definition's getting a lot broader too, because you have things like Facebook where so many people get their news and stuff, and Twitter and Snapchat and whatever else it may be, and so it's getting more and more difficult to regulate all of the facets, all of the media, all of the methods, that those things are put out in front of us. Okay, so I on a day-to-day basis, I find articles about this kind of stuff that's going on, and I find each and every one of them kind of interesting. So. So the Second Amendment, right to possess guns. There haven't been that many Supreme Court opinions. There's been lower court opinions, but not that many Supreme Court opinions. But Heller and McDonald were two of them, one Chicago and one, I think, the District of Columbia or Washington, D.C. And in both cases, the localities, be it Chicago or D.C., tried to put some limits on the types of firearms. Limits on pistols in this case, I think in both cases. And they went to the Supreme Court, and the Supreme Court ruled no, that people did have a right to keep a pistol in their own house. Can we have a bazooka in there? Maybe not. Okay, and certainly they've even put restrictions on like automatic firearms. We're not supposed to have automatic firearms. Semi-automatic, okay. Automatic, no. There's talks about putting limits on the size of the clips, that you might be able to get. Okay, and so it's an ongoing debate. When I say here it was a narrow opinion, meaning that it applied just like to that gun again, or that type of gun. It didn't make it wide open and say, oh golly, anybody and everybody can have any type of gun that they want. It wasn't that type of an opinion. It was very narrow. And might it lead to increased litigation? Well, yeah, maybe. It's certainly not going to stop other litigation in regards to gun control and those types of things. And I think the Supreme Court purposely did that. Again, it's a right that we hold dear. Most people do in the U.S. They hold it dear, and yet it's a right that we've already put some limits on it. And so, what's the proper balance there? I think the Supreme Court wants to be able to weigh in on that. Some other amendments and things. The Fifth Amendment, and we'll spend a better part of a chapter kind of talking about the Fifth Amendment, some of the things that go on with that, especially in regards to eminent domain. Okay, due process, right? You have the right to remain. How many people say I take the Fifth? That's what they're referring to. The right to remain silent. Okay, the right to not have to testify and incriminate yourself. Okay, the Fifth Amendment's got a lot in it because it's got that, right to remain silent, that type of stuff, but it's also the eminent domain. Okay, and due process has to do with that. In other words, government has a right to take some property, but it has to be after due process. Okay, there's condemnation proceedings and those types of things. Has to be just compensation. There has to be other, there has to be a structure to it. Okay. As we talk about due process, decent amount when it comes to enforcing the laws and whatnot that we have here in the U.S. When I say public use in terms of eminent domain, the definition of that is expanding. I think we all go back and we say, okay, we understand the government needs to build roads, and so we totally understand that in some cases they're going to use the power of eminent domain because they have to get a road from point A to point B, and that may be the only way to do it. Okay. Well, that's fine, but then what happened when maybe along came railroads? Should the government use its power of eminent domain to allow a railroad to pass through somebody's property because it's really important? of course, the government said yes, and then pipelines maybe became the same thing. Well, so then what happens when the government condemns a piece of property, say in downtown Timbuktu? It's a perfectly legitimate piece of property, maybe even have an ongoing business, but they condemn it and allow it then to be sold to Mega Mart Corporation or whatever it might be, because they're promising to move to town and bring a gazillion jobs with them. The courts have said that's okay too. Okay, and sometimes that makes us all a little bit irpy, but it's not that big a stretch really from the railroads, which is private business, or pipelines, which we all kind of go, yeah, those make more sense for whatever reason. Okay, some amendments and basic protections. Due process, again, procedural, proper notice and hearing, and, the Miranda rights are part of that, the right to remain silent, et cetera, et cetera. Substantive property rights affected by government action or eminent domain. Again, due process applies to that, meaning that, ultimately, our land may be, or our property may be taken away from us, but not unless due process is there and just compensation as well. The Fifth Amendment was a federal law. It said that these protections apply in federal cases. But the 14th Amendment, which we call the incorporation document, poured over those rights to the states, meaning that the state can't take property either unless there's due process. Okay, and so it said that state and local laws too have to abide by the due process rules when they deal with people, when the public deals with people. And this, I think, was part of your guys' assignment when we talk about equal protection. We talk about minimum rationality, strict scrutiny, or compelling state purpose, or quasi-strict scrutiny, and how they're going to look at some of these things. And so minimum rationality says, there are cases where it just makes sense that we're going to allow there to be some divisions, let's say based on gender. Okay, it's okay to have men's and women's bathrooms separate. Okay, although that one's even getting a little more scrutiny. Maybe that one's going to become quasi-strict scrutiny here pretty quick. I don't know, but it's okay to have men's and women's locker rooms separate. Okay, and so those are minimum rationality, and so there's cases that would come up with the court, and that's the standard that they would use. Strict scrutiny means there has to be a compelling state purpose. Okay, I think that Trump's travel ban that he wants to put in place now, it's expanded to 9 or 10 nations, whatever the number is going to be subject to strict scrutiny. Are we discriminating against people based on religion in that case versus based on the nation states where they come from? Okay, and so that one, they're going to have to prove that there's a compelling state purpose for that ban to be put into place. Kind of my interpretation, I guess, maybe of this strict scrutiny. And then quasi-strict scrutiny gets to be a little bit more, should women, keep in mind that until recently it hasn't been the case. Should women be allowed to be in the Rangers or Navy SEAL teams or those types of things? And in the past, no. I mean, up until a year or so ago, kind of no. And those things are opening up more, okay? But quasi-strict scrutiny said that, maybe we can allow some situations because, again, there are significant differences, okay, that might how do you say that without putting my own foot in my mouth? But there's differences between the sexes that might allow for some differences that aren't minimum rationality, but as we go up the ladder in terms of important things for the U.S., the interests that we have. There you go. I'll let the book describe it maybe better than I. So, equal protection issues. This has become a legislative apportionment, how we divide up. That's been for voting rights and those types of things. This has been catching a little hell because, gerrymandering used to be the term where folks that had the power to would try to divide up districts so that it would enhance the ability of one party or the other to elect their folks to state legislatures or potentially even the U.S. House of Representatives. Okay? Real estate, racial segregation used to be a bad history point in the U.S., but not quite so much anymore. Rights of legitimates and illegitimates, you don't hear that so much anymore either, but it used to be a big deal. Children born out of wedlock and what kind of rights and whatnots they might have in relationship to their, perhaps biological. Jury makeup, should we be able to dismiss somebody that has fervent religious beliefs? If you were on trial for, maybe something that you thought was very, very Christian-oriented, for example, should your lawyer be able to dismiss somebody that's a devout Muslim on the jury because you don't think you would get a fair reaction from that person? Believe it or not, up until 20, 30 years ago, that was perfectly appropriate. Now, again, it might be more of a quasi-strict scrutiny thing, that there might be cases where that's allowable, but other cases where it's not. Voting requirements, welfare residency, rights of aliens, property tax to finance schools, et cetera, et cetera. How do we look at those things? Very, very important and a very big part of our debates now. When we're talking a lot more about immigrants, both illegal and legal, and the types of rights that they do and maybe should have or shouldn't have. So, timelines for. We're going to talk later on at length about the Fair Labor Standards Act, so I wouldn't worry too much about that. I don't know that a lot of those other ones are terribly important either. So, we're going to talk about regulations a lot more thoroughly later, too, and we talk about administrative law. Is there any limit to the extent regulations impact our laws? Well, we'd like to think there's some limits, but maybe not. How can an individual or business organization challenge regulatory authority? And we'll talk about that when we get into administrative law. So there you have it, Chapter 6. Ooh, I got a little long-winded there, sorry.